What is this?
This is 96, which is a GO which amending.
GO 96.
96.
This is
Amending Rule 22.
This is statutory.
Statutory. Article 309.
Statutory.
Yes. Your Lordship, see the notification top itself sentence. In excess the powers conferred on the provisions to Article 309 of the Constitution.
Yes.
Clause B has been amended. Earlier it was 3%. Because of the central amendment with the Disabilities Act, they made it a 4. Following the clause shall be substituted, namely, out of 50 appointments to be made. Out of 50 appointments, these are 50 appointments, they have to go by like that. To be made on the basis of the open competition. On the basis of the open competition, 4 appointments shall be reserved under the direct recruitment to the person of the benchmark. This 4%, I have no quarrel with that. I have a quarrel with it saying that you should be direct recruitment to person with a 50%, and then followed with a B. Should we come to next page? In clause E, proviso to Roman 2 following substituted, the clause 6, 31 and 56 turns in each cycle 100 vacancies shall be allotted to the blind, low vision, deaf, so and so, including cerebral, so and so, etc. This roster fixation is illegal. This roster fixation. The points of 6, 31, 56, each cycle of 100 roster, which is they maintain, they cannot do it because this particular roster they can't fix it, and they can't take it from the open quota. It has to be horizontal. Because this is a special reservation.
Kindly read it again.
I'll read both A and B so that the following clauses shall be said. Out of 50 appointments to be made on the basis of the open competition, 4 appointments shall be reserved.
You are not aggrieved by this one.
Agreed to the extent of 4%, I am not agreed. This open competition they are interpreting as a general quota. And coming to the B is concerned, inserting clause E, roster points, 6 that
they are discussing.
Page 153, B I was reading.
B.
Fixing the roster points.
How you are aggrieved by A? You said 4% you have no quarrel.
No quarrel. But on the basis of the open competition, it is being interpreted saying that it is only in the open quota they'll give. That is general quota they will allot. If the open, I'll show their counter. In the general quota they won't allot this 4%. If that is allotted, in fact, it infringes Balaji principle also in more than 50%. 4%. This open competition is being interpreted as it is under the general quota. Because they are following vertical reservation. They'll fill up in the open general quota this 4%. I'll take what there is stand in the counter, I'll just take.
This 4% is special reservation.
Special reservation, physically handicapped.
So this should be cut across the quota.
Yes, across the quota, there can't be any roster points.
Yes. You have pleaded in your petition in this way that this is the flaw in the.
Yes, fixing the roster points and the 4% to be accommodated in the open category.
There is a foundation in your writ affidavit.
Yes. Page 180 is the fixation of roster points. 100-point roster. Page 180.
Who needs? This is about. Where is his volume?
Serial number 6, 31, 56, 82. Out of 100-point roster.
Yes, any other flaw in your opinion?
Hmm?
In clause B, is there any other flaw apart from
Only
this?
fixation, only fixation of the roster point, that's all.
Yes.
In fact, one of the recent GO, what they say, Your Lordship may just come to page 182. In respect of while issuing the woman as a horizontal,
And which is, where was that? Open and horizontal?
page 182, Lord. They issued it as GOS number 3,
182.
182.
182 is GOMS 3.
333.
Yes.
That is in respect of women. But what, well, their observation that horizontal is there. Para 3, Your Lordship. They know the law. The Honorable Supreme Court of India in the case held in Rajesh Kumar Dharia, Rajasthan, 2007-8 SEC, which Your Lordship have seen. The social reservations in favor of SC, STs, OBCs under 16.4 are vertical, and special reservation in favor of the physically handicapped women, etc., under Article 16.1 or 15.3 are horizontal reservation. This they have issued on 10/2/2024, just before this notification.
GO 29 says otherwise.
Yeah, otherwise.
Let us again see GO 29.
No, not GO 29, GO 96.
No, assume GO.
Yeah, new GO 96. 96, 29, otherwise.
Page number
Page 152.
150.
152, you know. As far as the notification is concerned, we're on page 54.1. Page 54.1.
Where is that portion which in GO 29 which treats this social reservation as horizontal?
29 it do not contain.
And that is exactly at page.
The GOMS 3, they refer to the horizontal, there is their view.
You are happy with 3.
I'm not, no quarrel.
You are only showing that they understand.
They understand, that's all.
Law, and
in spite of that, they are not following horizontal, they are following vertical.
But in GO somewhere you are reading GO 29 that it is treated to be a vertical, horizontal. In GO 29.
29 it is not subject to correction.
That is what read out.
GO 29, 178.
29 doesn't deal about it.
GO 29 is at page
178.
178. 130.
178. 178.
What you were reading was from their notification.
Yes, notification.
In the notification, it is.
Their understanding is that it is horizontal only.
That is at page.
Page 182. Para 3. This is their issue for the women. But they also specified physically handicapped also. But for the physical handicapped, they have not issued.
No. Notification.
A notification is page 50. Page 50. 4.1.
In fact, that problem is at 4.1, page 50.
Yes, madam. There will be reservations to direct recruitment in respect of scheduled tribes, scheduled castes. Page 54.1. Scheduled tribes, backward class and economic sections, and persons with disabilities, and horizontal reservation only women and meritorious sports persons.
Horizontal is rightly described.
For women, but not physically handicapped. Physically handicapped vertical. First limit. Reservation will be direct recruitment.
Disability should also have been part of horizontal.
Yes.
That is the only defect.
What is only? The physically handicapped cannot be vertical, it has to be horizontal.
Yes.
As per the Rajesh Kumar Dharia, which in fact they understood correctly in the very same month when they issued GO.
Yes. Anything else?
One. Rajendra Kumar Dharia, I have already read Your Lordship para 5 and 6 with regard to the horizontal special reservations, we have already read para 6. Special reservation has to be horizontal. With regard to roster point, I just want Volume 2, I think he collected, my lord, court officer. Just one judgment I want to show. This is not there in the compilation, my lord.
Yeah, but why rule 22A and B are bad in law?
Yeah, bad in law.
Statutory rule, why these statutory?
Yes, statute rule is bad, contrary to the principles of horizontal, as initiated Rajendra Kumar Daria and all other cases.
The rules are at page?
152, my lord, 152. By this GO, my lord, rules have been amended, inserted accordingly.
So that is, you are agreed only up to the roster point and?
Horizontal, well,
horizontal.
not vertical, horizontal.
Yes.
The one judgment of Andhra Pradesh High Court I want, my lord, court officer, volume 2 here. Please submit our court officer. Volume 2, your lordship, just kindly take up.
We have given it to you.
Two copies, page 275, your lordship. $275, your lordship.
Yes.
This same rule 22A was under challenge. Your lordship may kindly come to me, lord, page 292, para 53.
Very soon was under challenge.
Yes. This is under single age, which will not be binding on your lordship. As my argument, your lordship will just take it. Single age judgment of Andhra Pradesh High Court, AP Online 21. Same very rule 22A, which was similar to this, was under a challenge.
This is capital A or small a?
Small a. I'll just check.
In Andhra Pradesh, it is capital A. In Telangana?
I'll just check, because this GO is showing it, I'll just check up under the rules what is the position. I think along with the reply, I'll just one para. At the time, I'll show that. Lordship may just see the judgment and then come to Lordship got it, page 275.
152 talks about only 22. Small a. 22 too small a. This 22 too small a in Telangana is pari material to 22A?
Yes, almost, almost. And the principle is, your lordship need not go into that. Principle is should be colored.
Take out these rules. 22A, because rules I don't think they have changed after bifurcation. After bifurcation, rules have not been changed only.
This 2019, no, 96 2019 subject to correction.
I will go to page 45 of that booklet.
That's a woman.
That is women reservation.
In fact, you 55 and 23, they both speak of 22 and 22 capitally. They speak about providing reservations as regulated 22 and 22A.
What was under consideration was 22A before AP High Court. So that is confined to women reservation. How does it help you?
No, your lordship may just see the para 53 of judgment. The purpose of horizontal reservation, your lordship got it?
Paragraph
53, page 292.
paragraph 53. Yes.
The purpose of horizontal reservation is to ensure that a minimum number of persons from the category are able to get post. Horizontal reservation cannot be implemented by reserving. This may not sentence I have read. The horizontal reservation cannot be implemented by reserving roster points and again permitting the persons of that category to participate in the recruitment process. Such a method is anathema to horizontal reservations that would effectively place vertical reservation, horizontal reservation on the same footing. In such a case, the protection given to horizontal reservation in India's case would not be available to protect such a reservation when cumulative reservations cross the bar of 50%. Even otherwise, no roster, this is another sentence, even otherwise, no roster point can be fixed in the case of horizontal reservation, as the set system reservation operates on a different principle. The reading of GMS 466 specific roster points have been fixed for reserve for women, same would be impermissible. The extent of GMS 46 reserve points, women same is not valid. Similarly, GMS number 99, dated 4/3/2013, reserving roster points, persons with a disability would be struck down to the extent of it reserves roster points for the person disabilities. Apart from the GMS 99 so and so 43 was issued earlier act for 3% reservation. The change of law and increase of reservation 3% to 4% of new act, which holds the field, has not been taken into account. The mandate, this is another, the mandate of section 34 of the rights of principles requires that Andhra Pradesh to create horizontal, they are relying on section 34 of the Disabilities Act. To create horizontal reservation, 4% in accordance with the provisions of 34 of 2016 Act, that would require state to enhance reservation to provide per person with reference to 3% to 4%. Your Lordship may just take them in the counter of the Service Commission, counter of response number 2, Milord.
Yes. Yes.
Para 31, page 19.
Yes.
It is submitted that existing rules provide rule of reservation laid down 22(2)(e), Telangana State and Subordinate Service Rules. This sentence is important. The roster point earmarked in 100, cycle so and so, allocated from open category. If open category is allocated, 4% increase will be there in the reservation. As already, in fact, 54, I think already 33% ST reservation increased from 6 to 10 also will not under challenge for lordship. Now in the state, 29% VCs, 15 SCs, 10 STs, this 4% open, it goes to 54%. Therefore, my grievance as far as the physically handicapped are concerned, one is that there can't be vertical, it should be horizontal. Second, there can't be roster points. Third, it can't be given open. Once it's horizontal, it becomes, your lordship knows, suppose number of people are not coming of merit, will they respect to downgrade the persons and accordingly they account for the respective community or category wise. Will I finally just reply to say section 34 they are relying. Your lordship may either take 34 or will my reply rejoinder to the response number 3 counter. Section 34, your lordship may just see. They are relying on that. Section 34 is only enabling provision. It doesn't say fix the roster points. That page 94, your lordship got it. Rejoinder to counterfeit file response number 3.
Yes.
This section 34, they are relying to saying that they fixed to enhance the 4% as a mandate. Second thing is that they fixed the roster points. That's not the correct reading of 34. Every appropriate government shall appoint in every government establishment not less than out of total number of vacancies. Total number of vacancies. Now, Your Lordship, I brought Your Lordship notice counter. They are reserving in open category. In the cadre strength of each group meant to be filled with a bench of disabilities, which 1% the subcategorization in that.
Just a minute. 19, 11, 24.
Yes, rejoinder to
R3 note, rejoinder to R3.
Yes.
Page 94, Your Lordship.
Yes.
Section 34. Every appropriate government shall appoint in every government establishment not less than 4% of total number of vacancies. Now, when I brought Your Lordship notice para 31 of their service commission counter, it is in open category only they are fixing, not in 563. 209 only they will fix. In the cadre strength, in each group, post to be meant to fill with a benchmark, of which 1% each shall be reserved for the persons of benchmarks of disabilities ABC. There is a subcategory among them. That is not for the roster point. And in fact, the Government of India, on the basis of this act, after enactment, issued a general circular. Your Lordship will get it, page 115. Page 115. Your Lordship may come to me, Lord, page 119. Horizontal reservation, Department of Personnel, Lord, Ministry of Personnel, Public Grievances, Government of India. Page 119, clause 9.
Yes.
Reservation for the backward citizens, SC/ST is called vertical reservation. Reservation category such a person with a benchmark of disabilities and ex-servicemen is called as horizontal. Horizontal will cut across the vertical reservation, and the person selected in quota benchmark have to be placed appropriate category of SC, STs, BCs. Have to be placed in appropriate category of SC, ST, OBCs, unreserved, depending on the category which they belong to, the so and so, meant for reservation of SCs, OCs. To illustrate, given there are two vacancies, so and so benchmark, disability so and so benchmark. One belongs to scheduled caste and other belongs to unreserved category. SC candidate with the benchmark disability shall be adjusted SC point in the reservation roster. Unreserved candidate with the benchmark disability, unreserved point in the relevant roster. In the case of none of the vacancies falls point of SC candidate under benchmark so and so shall be adjusted future against next vacancies. This is a principle. This is the Government of India following all these things. It has to be horizontal and respective on the basis of merit he should be adjusted in the respective slots, not in open category. And by fixing a roster point, in the rosters they to be accommodated in the respective categories, not as a roster point. And in fact, I need not trouble your worship, Andhra Pradesh government also deleted. In fact, it was following earlier, it has deleted benchmark disabilities, your worship. It starts at page 123, August 2023. Any of the so many judgment it has taken a decision, page 134. The roster points earmarked existing roster to categories of women, person with a bench disabilities, ex-servicemen, meritorious shall be deleted.
134 clause.
134 2, class 2. Top.
Roster point.
Roster. GMS 77 is amending the rules. The roster point earmarked for existing roster to the categories of women, person with a bench disabilities, ex-servicemen and meritorious sports person shall be deleted. Roster points earmarked.
This is also DOPT instruction.
This is the Government of Andhra Pradesh. Government of Andhra Pradesh.
Andhra Pradesh.
In the service rules. Therefore, my submission is that 34 is only enabling provision. Therefore, Fixing the roster point has to be struck down. Obliged, my lord.
Anybody wants to add anything for petitioner?
My lord, may make submissions, my lord, or virtual?
Mr. Sudhir, which is your writ petition number?
My lord, I was under the impression, my lord, today there are other couple of senior counsel. If they are not doing, my lord, I can do it.
If
I thought,
nobody
Lord,
else, if nobody else is there to argue, you argue your matter.
Yes,
The only request is not to repeat the same thing.
My lords,
I will.
You may
I
add.
will.
my lords, Learned Senior is appearing in 28576. Since most of the arguments have been covered by Learned Senior here, we'd circulate a small note to your lordships.
You don't wish to advance oral arguments?
As such, more or less, all of them have been covered, my lords.
Do you wish to advance oral
No,
arguments?
my lords,
Or you
we'll
are happy
circulate.
with your written submissions?
We will submit a note to your lordship. That is all. We have no arguments to advance
So
at this
please
stage.
give us which is the WP number in which you are appearing.
I do not have the. I'll circulate this. 28576, my lords.
28,
WP 28576.
28,
576, my lords.
576
That is right, my lords.
of 24.
24, my lords.
And you are on behalf of senior.
L. Ravichandran, my lords. I'm the counsel on record.
Gentleman is senior, sir. He's,
Yes, please. Yes, you give your written submissions, we'll consider.
My lords, 2 more copies are yet to come, my lords. I'll pass it on to the court officer as and when they come.
My lord, may
Yes, sir.
submit. Yes,
Lords, these are the submissions with respect to the contrary stance that they've taken in a previous writ where GO 55 was challenged, vis-a-vis the counters filed in the challenge to 29. The note on the writ is yet to come, my lords. I've asked for copies to be made. They're coming, my lords.
Yes, that's all.
That is all, my lords.
Yes, yes, Mr. Sudhir.
my lord,
Your
initial-
WP number, your WP number, please.
my WP number, my lord, the 32842 of 2024,
Yes.
item number 74. My lord, my colleague will give the propositions, my lord, points for consideration. Copies may be taken, my lord. I have made, I thought, my lord, I made the things little easier, my lord, by propositions. My lord, before I take your lordship to the controversy in the present batch, my lord, I just need a couple of minutes to explain as to Public Service Commission role. Not that lordships are not aware, but Public Service Commission is expected to an independent body. My lord, expected to conduct examinations, my lord, in a transparent manner, non-opaque and transparent manner. And my lord, 2011, my lord, though I'm not relying upon that, my lord, 2011, my lord, the examination was conducted, matter went up to Supreme Court, and then the whole examination was set aside because the procedure adopted, my lord, in calculating some questions, my lord, is not correct. So they had to redo the mains. So now all of us will be arguing, my lord, saying that the present procedure that is adopted is incorrect. And therefore, my lord, the mains have to be reconducted will be our target. By redoing the exercise under the old regime. I'll come to that. My lord, first of all, you lordships have seen, my lord, yesterday, my lord, senior counsel argued as to the very cancellation being wrong. My lord, at this juncture, your lordship clearly see, my lord, my friends have said that the sputter issues were already considered by the single bench, which was confirmed. Therefore, that cannot be gone into. My lord, I respectfully, my lord, disagree with my friend because
Before entering into that, in your writ petition, challenge is made to what?
my lord, challenge is made to GMS number 29 and GMS number 96. Two issues. Therefore, my lord, I think it would be not proper, my lord, but I will be only mentioning about it as to why 29 is bad, politically colored, and how it happened, I'll have to explain. My lord. That's what I'll explain. My lord, first of all, there was your lordship knows, my lord, by my senior friends who have argued that there was a notification that was issued on 26/4, my lord, in the propositions also have given 26/4, 2022. For the Lordship kindly see, chronological events I have given important dates along with the propositions. The Lordship kindly, for Lordship's convenience, Lord, I have given the dates and events, Lord, in a chronological manner.
That is second date.
Yes, Lord. Note,
Yes.
no, first date, Lord, is GMS number 55. That was issued on 25/4/22, and then next day, my Lord, the notification was issued.
Yes.
Now, after this notification was issued, my Lord, there were two preliminary examinations conducted. One preliminary examination was set aside, my Lord, because there was a leakage. That speaks the capacity and credibility of the public service. There was a paper leakage. So therefore, my Lord,
That has been narrated in quite detail, biometrics and all.
no, I'm only trying to say, my Lord, after that, the second one is also over. That has been explained to Lordship, but I'm not trying to repeat, only to say that the judgment categorically says redo it, reconduct. Of course, there was a mention about contempt, the way it was withdrawn, on all that. My Lord, I have mentioned about those also. My Lord, 90, if your Lordship takes serial number 12, serial number 11 in that particular thing, SLP and all that, my Lord, letters were withdrawn, was given at serial number 10 on 8/2, and GOMS number 29 was issued on the one which is on the challenge is also on 8/2. SLP was withdrawn on 19/2. Cancellation of the earlier notification on 19/2. Issuance of the new notification is on 19/2. And then, because we are challenging 29, we are bringing to Lordship's kind notice, my Lord. Any change of situation, change of policy, or change of procedure has to be, my Lord, legal and valid. And incidentally, my Lord, there was a change of political scenario at that particular time. And there are catena of judgments, my Lord, latest being, my Lord, the Honorable Supreme Court, my Lord, in state of Tamil Nadu and what's this, Shyam Sundar, about, my Lord, change of political bosses, immediately changing the procedures. My Lord, will be very much applicable here. Because earlier to 22, my Lord, there was the 22 was issued in the earlier regime, and two preliminaries were wrongly held. Matter was they're supposed to reconduct the preliminary examination, third preliminary examination. Instead of that, they have changed the process by 29 and issued a new notification on the very same day of cancellation. And Lordships will be surprised to see that cancellation is not by the government. Or a Public Service Commission is only an agency. The recruiting authority is the Public Service Commission, but the appointing authority is government. Government has already given indent. And the process has started. Public Service Commission has no business to cancel because there is no cancellation by the government saying that we will issue a fresh notification or we will give a fresh indent. And the reason that they mentioned, my Lord, in the counter also, here or earlier, my Lord, is that there are 60 more vacancies that have come up. Earlier 503, 60 more vacancies have come up. Therefore, we have to redo it. My Lord, kindly appreciate, my Lord, for a minute, have a look at the cancellation. What is the reason given? For a minute, my Lord. At page 200 of my paper book, page 200. There is no reason.
But Sudhir, is it correct that this cancellation notification was challenged in the writ petition?
That's what I'm saying, my Lord. The writ petition, my Lord, where Justice Karthik has not entertained, has said that I'm not going into these matters because you have already participated.
No, participate is different. Yesterday, Mr. Rajshekhar informed that this was also subject matter of challenge in the writ petition, which is dismissed, writ appeal, it is affirmed, now pending before Supreme Court.
That
On
is
6/12 it is.
Absolutely correct. But what I'm
Can
trying
you
to
tell us WP numbers? WP numbers where it was subject matter of challenge?
Red petition. Red petition, my lord, 21223 of 2024,
212.
39 of 2024.
Kindly repeat the number.
My lord, red petition number 21239 of 24.
And writ appeal number.
My lord, there is another red petition also, my lord. There are two red petitions. The other red petition, my lord, is 22320 of 2024. Two red petitions.
And writ appeal number.
Two writ appeals, my lord, 1188 of 2024, 1190 of 2024.
Yes.
But last occasion, Lord Speaker, I recall my friends have passed on the Justice Karthik Balot single judge's order. But there were several issues, including wrong questions. The learned single judge has discussed only about wrong questions and then said he has non-suited us. Therefore, he has said, that I am not going into other issues. I am not answering other issues. So the grounds that we have raised with regard to cancellation and all that have not been into. But
Even otherwise, this P12 is not under challenge before us also.
Which one, my lord? I am not for a minute trying to go back to the same route, my lord. I am only trying to bring it lordship's kind notice how 29 is politically motivated, how this has been done in such a crude manner. I am not going into the notification challenge, my lord. 19-2 cancellation and all that, my lord, cancellation, withdrawal. There are so much of arguments. One thing is that the division bench and the single bench have not discussed and then they decided against me. Only thing is, but single judge said, I'm not going into those things. Division bench said, because the examinations are at the pipeline, I don't want to interfere. Matter is pending. Anyway, I'm not going on that. But the fact is, I'm drawing a lordship's kind attention to page 200 only for the purpose of to bring it lordship's kind notice about the judgments I'm going to cite to show that this has not been done. It says public interest. The cancellation was in public interest. It's not public interest. They want to bring about a new procedure under 29 because there is a new regime, new political party, new political guru. Therefore, the whole thing has changed. This was held to be illegal by lordships in several cases. Just because there is a change, they don't want the earlier notifications to go on. And then they want to show some benefit to some group of people. How they wanted to show, I'll take your lordships to. So in the backdrop of the way they conducted themselves, in filing the SLP, withdrawing it, issuing GMS number 29, withdrawing this, and the lordships will be surprised to see the reason for cancellation is public interest. The lordship LC page 200. It says the only reason said is I don't know how it is a public interest to validly issued notification is set as cancel, that too not by the competent authority, and then public interest. And the reason mentioned in the present counter are there also because new 60 vacancies have come. Therefore, I wanted to add those also. If you want to add 60 more vacancies, you could have given addendum. There is no necessity for cancellation because the present government wants to show that the new notification, so many employment was given in the teeth of the present regime, not in the old regime. And lordship can see page 156. The notification itself says it can be added. Vacancies can be added. Page 156. So therefore, what they are saying that 60 vacancies have to be added is a lie, blatant lie. Blatant lie. Page 156, if your lordship sees, which was the 22nd, 2022 part of 22 notification. It categorically says Public Service Commission has the authority to add or delete. Page 156.
Clause.
Sorry, Bharat?
Which para
Yes,
clause?
sir. Yes, Bharat. Page 156 on the top, important note.
Yes.
Immediately after the table, the number of, say top para, 156. The number of vacancies and departments are subject to variation on intimating being received from the departments concerned. addition of vacancies, if any, will be accepted only before the date of preliminary test. So after the preliminary test is cancelled by the second time, well, if they want to add, they can add. There is no necessity for cancellation. So the reasoning stating is, well, is absolutely contrary to the notification. Now, coming to the concept, well, of whether they have, first of all, Public Service Commission has a power, whether it comes under contempt, the fact still remains whether it is a public interest or whether it's a lie to say that just for the adding purposes they have done. Most important thing is your lordships asked what happened, how are you affected? Yesterday also your lordships are saying, my lord, by issuance of the present notification, persons earlier notification in 2022, the date of eligibility criteria is not the date on which the notification was issued, which is 26/4/2022.
That has been argued at length, all these aspects which you are.
One aspect I have to say, my lord, I am only trying to say that was not, with respect to my friend, my lord, was not how we are prejudiced is what I am going to explain. Because persons who are not otherwise eligible as on 26/4/2022.
Yes, this was argued by Mr. Sundhi yesterday.
No, I'm sorry, my lord. Lordships may kindly appreciate my friend could not properly explain his by understanding, my lord, subject to what lordships may say. The persons who are not eligible has become eligible now for 503. 503 vacancies. My lord, person who was in degree first year in 22, he became eligible. Now, my lord, I am eligible in 2022. Now I am made eligible now also. But then persons who are not otherwise eligible in 2022 made eligible for 503 vacancies.
Yes, sir, we inquired, and if I correctly remember, we required that we observed that by this zone of consideration is enlarged.
Enlarged, not enlarged. Not enlarged, my lord, I cannot say anything. I cannot say you cannot have more number of people. But what I am saying is ineligible persons are made eligible for 503.
They are very much eligible on the date of present notification. The only you are raising eyebrows on the ground that the previous notification was cancelled, because of which they became eligible. Because of which they became. That has been explained in quite detail yesterday.
My lord, now coming to the 29 and 55. Before 55, my lord, let me explain to lordship, there was 570. Give me number 570. My lord, which is filed by the respondents in the counter. 570 is there. 570, my lord, is dated 31/12/1997. Now we are in 29 regime. Before that, 55, I'll come to that. This 570 fell for consideration before this honorable court. You not may kindly see that there was a judgment. 570 particular clause was set aside by this honorable court division bench. Matter was carried by Public Service Commission, APPSC then, to honorable Supreme Court. Supreme Court reversed the order by saying that 560 is valid. 570, I'm sorry, but 570 is valid. 570 is valid. That is Balaji case, Balaji Bajawat. Now, the judgment of the Honorable Supreme Court, my lord, the lordships will get at the count, along with the counter they filed, my lord, in the present case.
Yeah, yesterday it was read out with, by Mr. Sundhi.
149, my lord. I'm just giving the date, page number.
It was read out yesterday. We have noted that.
I am only trying to say, my lord,
you can eschew repetition. We are ready to hear as long as you want, but please eschew repetition.
There may be some interspersing of some sentences, my lord, pardon me. And what all I'm saying, my lord, is that after 570 Balaji judgment, 55 was issued. Balaji judgment, kindly appreciate the note, my lord, the dates, this will be very well. So Supreme Court judgment was 8/4/2009.
Yes.
And 55 was issued much thereafter on 25/4/2022. A new procedure in supersession of 520, despite the fact 570 was validly made. That's what the Supreme Court said in 2008. Then, my lord, in 22 they came. These judgments, this writ petition, this 55 was challenged in a batch of writ petition, in which, my lord, Public Service Commission filed a counter affidavit.
Yes, it was pointed out that 1/50 is the highest ratio in the country. A chart is prepared, a table, it was shown yesterday.
Say, my lord, the particular portion of the counter affidavit categorically says Balaji is not applicable. And then now for changing from 55 to 29, kindly have a look at the 29. Two reasons are given, my lord. Only two reasons.
Yes, one is the court cases and the second is Balaji.
Second is Balaji. Both
Yes,
the cases.
yesterday it was pointed out, Mr. Sudhir.
That's what I'm sorry, my lord. I'm only trying to say this 29 is illegal and unconstitutional. For the reason, my lord, kindly see 29 for a minute. My lord, my friends explained to not just, my lord, how 55 is valid. Now, it is not a question of at this stage whether a reservation should be applied or not. Everybody, either in 29, either in 20,
In your case, 29 is at page?
page, my lord, 139. What they have done by changing, my lord, is violation of Article 14. That is what I demonstrate now.
No, Geo 29 is at page?
139, my lord. What they have done, there was no proviso earlier. There was no proviso earlier. And a portion is deleted. Kindly, if you not, I'll read the B, my lord. The number of candidates to be admitted to the written main examination, conventional type, would be 50 times to the total number of vacancies available in each multi-zone. This is deleted. What is deleted from 55, my lord? I'll read it now. Duly, what is duly following the rule of reservation for communities, gender, EWS, PH, and sports. That was there in the 55. If you lordship for a minute have a look at the juxtaposition, kindly go to page.
Why you are taking us again, Mr. Sudhir, to that? Today, Learned Senior Counsel even prepared a chart in juxtaposition. We were taken to those provisions.
I am only trying to say, my lord, that by what you now kindly see, my lord, I just read out the propositions. That would be good enough, my lord. I have made propositions for lordship. I'm sorry. Kindly take the propositions. What has, before I take your lordship, my lord, I just say this. By virtue of counting 563 into 50, OCs who are not otherwise eligible for SC, ST, other vacancies, OCs have become more than 1:50. There is a crisscross. But earlier, under 55 regime, what they can do is, if there are 209 vacancies, that has to be 209 into 50. If the SCs are 10 vacancies, 10 into 50. All that is brought, everybody is compartmentalized. Here, what has happened, now by virtue of combination of all, what has happened, my lord, is that the person's OCs, instead of 10,500 or something, my lord, it has become 1:100 and 1:15, 115, by virtue of the fact, because a OC candidate writing examination, as per the notification, 1:50 only should be called. Whereas by virtue of taking even SC, ST vacancies for the purpose of computation of head count, my lord, OCs have become, my lord, 1:115. I have given the table. You not just already seen the table. Other thing is, once the lump sum wholesale is taken, 563 into 50, what they are doing is they are only finding out the proviso says, I'll just say this and go to the other issue. Proviso says, if there are not many candidates in the respective reserved communities, in the lump sum, let us say, SCs are only 10 vacancies are there, 10 into 50 you have to take 500. If there are 400 people already in the topmost meritorious, who should be treated as meritorious MRC, they are called as. They are not. They are counted towards the 1:50 for SCS. That cannot be done. Is right from Indira Sahan is saying persons who are selected are under MRC quota, that is under open quota, who are MRCs, that is meritorious reserved candidates, cannot be counted for the purpose of computation of reservation. Now, when you want 1:50, what you are saying is we will see that lump sum thing, and then how many SCs are there, that is MRCs, will be excluded. Remaining people, we will ensure that we will get 1:50. May I just read one proviso and leave it there? this proviso talks specifically about including some more candidates. For a minute, provided that in case of any shortfall, that means if there are that number of SCs or OCs or BCs or the other category persons, not even a single candidate will be picked up. Now that shows OCs, one group are benefited. They are going one is to more than 1 is to 50. But if there are about 50 number of SCs already in the open pool, but they were also counted towards the 1 is to 50 for the purpose of SCs. And then only that many are being called. Not counting those candidates will lead to a situation where down below you have to go. You have to take 1 is to 50 for SCs separately. Instead of that, by making it, both ways, some groups are benefited, some groups are beaten.
So all this has been argued in the first half today itself.
But I just need to read, I'm sorry, I am repeating certain things. But I just need to repeat. Only proposition you not speak kindly take. Proposition number 1.
Yes.
If you not speak kindly. Whether following GOMS number 29, dated 8/2/2024.
Is it there? Have you mentioned the proposition in your submissions?
I have
Yes.
just
Let's go by that. Yes.
that's the crux of the issue, Marut.
Yes.
Whether following GOMS number 29 led to denial of several deserving reserved candidates to participate in the main examination, in as much as meritorious reserved candidates who are also counted for the purpose of 1 is to 50 while calculating the shortfall in their respective categories. The answer is yes. Counting meritorious reserved candidates who are entitled to be admitted by virtue of their own merit on the strength of their marks within their respective reserved categories is unconstitutional and violative of the law laid down by the Honorable Apex Court right from Indira Sahan, and reduces the opportunity for other deserving reserved candidates lower down the merit to participate in the further selection process by counting 1 is to 50 ratio. This is what I am trying to explain. Next, whether respondents violated 1 is to 50 ratio insofar as ST, BC, A, C, and E as the candidates selected in the above categories selected as MRC are also counted in their respective categories. Petitioners 1 to 3 are affected like this, as they could not be admitted to mains exam. The answer is yes. But the 1, 2, 3 could not be admitted because in their respective categories, if only they had taken 1 is to 50, they would have been in the selection process. 3. Whether illegally expanded competition for OC, EWS, BCB, BCD is adversely affecting those who fall within 1 is to 50. But there is other grievance. Those who are entitled only for 1 is to 50 have a grievance because unnecessarily we have expanded more than more number of OCs have come. Whereas this is 3. Whether taking overall vacancies, this is important. Whether taking overall vacancies, that is 563 and applying 50 times, that is 28,150, led to many OC, BCB, BCD candidates who are over and above 1 is to 50 are benefited. So because of that, this number has increased. It has 1 is to 50 is violated. In other words, for the purpose of head count, even reserved candidates were taken into account for which they have no right whatsoever. This when you are counting for 563 into 50 and then calling OCs, they are being counted against reserved vacancies, which is not permissible. They should be counted 1 is to 50 only against OC vacancies. Then, item number 5, whether GO 59 is totally unconstitutional and discriminatory in as much as one group of people, that is OC, BCB, and BCD in the present case, are benefited beyond their limits of 1 is to 50 ratio. Other reserved groups were restricted in as much as MRCs of those categories being counted under reserved categories while calculating the shortfall. The answer is yes, GOMS number so and so is unfair. 6. Whether following GOMS number 29 would violate the very clause of notification prescribed in 1 is to 50 candidates for main examination. Admittedly, in OC, BCB, BCD, the ratio of selection is exponentially high. The answer is yes. Following GOMS number 29 distort the clause mandate of notification that candidates will be admitted to mains in 1 is to 50. They themselves violated it insofar as OC, because there are more number of people. I've given the chart also. That was not denied by. Then, my lord, 7. Whether there is a need or justification to bring. This is important. 29. Just a few days before the notification, when GOMS number 55 is in force, in existence. The answer is no. There is no apparent need or justification for the said amendment. The abrupt issuance of the said GO raises question of arbitrariness, procedural fairness, especially on 8/2/2004, while the earlier notification was much there in the courts. Well, just before notification that was issued, and there is no basis also. The basis is also unsustainable. Whether the state is justified in taking a U-turn after issuing GOMS number 55 and defending and justifying the same in reputation so-and-so, challenging 55. But the counter I filed before Lordship Public Service Commission says 55 is the most important thing. 55 we have issued taking into account various reservations that are available in state of Telangana, which is all this is mentioned, and now, my lord, they took a U-turn. And then may I just take your lordship to 9. Whether there is a justifiable reason to issue GOMS number 29 and amend GOMS number 55 when the matter about the validity of GOMS number 55 is sub judice. They have not suspended. This audible court, my lord, matter is sub judice. They have interfered with the judicial process. Then, my lord, the reasons, 2 reasons mentioned, my lord. I'm sorry, my lord, 10 you lords pay for a minute. Whether the reason for amending GOMS number 55 as mentioned in the counter, that is several writ petitions are pending, can be a ground at all, leave alone a reasonable ground. No. Whether the other reason to amend GOMS number 55 following Balaji is justified, more so when the said judgment is not applicable as mentioned by the very respondent themselves, that is state in their earlier counters. And other thing, my lord, Balaji was issued in 2009, 55 was issued in 2022. Much water has flown because they said, Balaji, we don't want to go. We don't want to go by 520. We have a new state. We have a new procedure. We have new reservations. Therefore, 55 is issued, which is justifiable. Everybody is benefited. All communities are benefited. All reservations are benefited. Is the counter in the earlier case. Now, my lord, there is again they fall back on Balaji. I can understand Balaji is issued after 55. 55. Several years prior to Balaji is issued.
Argued at length, Mr. Sudhir.
Yes. Whether it is open for the respondents to change their version, stand without any reason and provocation. So, whether a validly made constitutionally valid, viable, procedure. This is where I am saying, I am relying upon the judgment, but I'll pass it on. 2011, 8 SCC 737. I'll give these judgments for citation.
What is the ratio?
That the political, because of the change of the political scenario, you cannot change it without a reason. They can do it if there is a reason. Generally also, policies can be changed, procedures can be changed if there is a valid reason. The reasons mentioned here, is not at all viable. And then you cannot go back from a good procedure to bad procedure. You can rectify. It should be the change should be more constitutional. Earlier 55, according to is more constitutional as held by them, as argued by them in the earlier cases. And even otherwise, I can demonstrate lordships how 29 is viable and acceptable for everybody rather than 55. 55, how it is.
Pausing here for a moment, where in previous round of litigation where 55 was under challenge, in which para of counter they have said that Balaji is not applicable?
Yes. Page, Lordship, kindly see, my writ petition counter at page 243, counter filed by Public Service Commission in the writ petition challenging the earlier GO 55.
Is it part of your paper book?
Yes, my lord. Page 243. It starts at 243.
Your last page is 239.
261, my lord.
But your writ petition last page is 241.
32582, my lord. 32582.
There are two volumes.
Yeah, it runs into 460 pages, bro. The book, the writ petition metal papers runs into 460 pages.
And the relevant page is 240.
243, my lord. Counter of the Public Service Commission in the writ petition where there was a challenge to 55.
Where is
No,
that?
sorry, my lord.
Relevant paragraph.
Page 261, my lord, paragraph 34.
Yes, paragraph.
Paragraph 34, my lord. There is a reference to Jafar Sahib that is also going out of this state pertaining to Public Service Commission Group 1. That was prior to 570. That was discussed, and then kindly come down to last but one para, sentence, my lord, at last but one sentence, my lord, at page 261. Similarly, it starts at similarly. Similarly, in APPSC, the Lordship got, my lord, Balaji, the Honorable Supreme Court upheld then policy of Andhra Pradesh in GOMS number 570, picking up for the candidates without following community reservation. Whereas, in the changed circumstances at this distance of time, Government of Telangana came out with a new policy under GOMS number 55. Your Lordships could see that, my lord, page 262. My lord, am I at 262, my lord? Moreover, the context in Telangana is quite different from other states. The state of Telangana was formed newly, and the posts under Group 1 were converted from state cadre to multi-zonal. There is a change. No other state in the country is comparable with the state of Telangana on this count. 95% of the reservations are provided for local candidates. The state of Telangana consists of two multi-zones, multi-zone 1 and comprising of 19 districts and multi-zone 2 comprising of 14 districts. Each multi-zone is a distinct and different. May I pause here, my lord? Now, 563 in a wholesale for all multi-zones are taken. Earlier procedure, my lord, they are supposed to take multi-zone. That's why they said we have a multi-zone. Therefore,
What happened to this writ petition? This is pending or decided?
pending, my lord. No, that was not suspended. Sub judice. Honorable Court thought it fit that is prima facie valid. They've defended. They specifically said there is a change in scenario here, state multi-zonal thing, which is not available anywhere in the other country, other states. Therefore, we have to do this. Earlier, under 55, my lord, multi-zone, my lord, every multi-zonal also they have taken into 50. Multi-zone, let us say in one particular multi-zone, my lord, 100 are there, 100 into 50. Here, 50 are there, 50 into. Here, my lord, it's a wholesale. They said we have done this because there are several reservations, several problems, several issues. Therefore, we wanted to compartmentalize. That was the stand. How does that suddenly disappear, my lord, just because there is a change of government? Now, they end a para 40, they said it's a conscious decision taken. Kindly see, my lord, page 263. I'm sorry, my lord. Just read 55. Ensuring equitable opportunity for all regions and communities. Continuing that para. So they have taken note of the regions, multi-zonal issues, communities. Now, my lord, everything is in one wholesale bucket. 563, there are some for multi-zone, there are some. All is made into one. So if there are, that means if there are 50 vacancies in multi-zone, multi-zone one candidate should be only 50 into 50. But because of the adding of all that, now there will be more than 1:50. They themselves are violating 1:50. That is exactly the reason why 55 was issued, compartmentalizing, saying that 1:50 is a biblical truth. It has to be like that because everybody will be competing equitably. Now, changed procedure can be better than that. You cannot bring a bad situation violating Article 14 because some groups are benefited, some groups are not benefited. Now, para 40 also says, a conscious decision is taken to ensure that each of the community and category will get their due share in public employment. Therefore, 55 is valid. A detailed counter is written. And they also mentioned about Article 355. at page of para 46, because the contention was if you take a separate groups, you will be the standard will be reduced, 335 is affected. For which Public Service Commission says there is a provision which says we can relax the standards, we have to relax the standards depending upon the requirement for the reserved candidates. So after stoutly defending this, coming back, my lord, and the reasons now, my lord, if your lordship kindly sees, they can change anything, change to a better situation, but they cannot go from bad to worse. And therefore, my lord, according to me, if your lordship now come back to my propositions, my lord, for a minute, if your lordship allow me. Come back.
You have already read out a dozen propositions.
Yeah.
Yes.
The fourth, what I'm saying is Balaji Badawat, which is not according to them applicable, is now
That you have already argued, yes.
Yes, Lord. Therefore, 29, the reasons are not acceptable, unsustainable. On top of it, you not test the reasons. And then see, forget, assuming my lord, they have a right to do, reasons are valid. But if Lordship says, my lord, it goes back to a situation where it violates Article 14 and 16. When there is a good, proper situation which is pending, where is the necessity for change? In that aspect, my lord, there are judgments which I am citing, my lord, saying that you cannot change it, it amounts to colorable exercise. 1982 SCC 471.
Volume?
19. My lord, I'm sorry, but this I have not. I'll be submitting along with my written submission.
No, you said 82 Supreme Court volume.
Yes, for volume 2 SCC.
Yes.
471. State of Punjab was Gurdayal Singh.
Yes.
Then, my lord,
Paragraph number.
my lord, paragraph 36, my lord.
What is the ratio?
Ratio, my lord, is that when power is exercised in bad faith to attain ends beyond the sanctioned purpose of power by simulation or pretentious of beyond the sanction, gaining a legitimate goal, it is called colorable exercise of power. The action becomes bad where the true object is to reach an end different from the one for which the power is entrusted, guided by an extraneous consideration, whether good or bad, but irrelevant to the entrustment. When the custodian of the power is influenced in exercise of its power by consideration outside those for the promotion of which the power is vested, the action becomes bad for the reason that power has not been exercised bona fide for the end of. My lord, lordships will be surprised. 29 was issued at the behest of Public Service Commission. 29 is not an independent thing done by the government. If your lordship
Yes, it was yesterday read out from the counter that proposal was given by the
Public Service Commission.
Yes.
Therefore, my lord, Public Service Commission, which is expected to act in accordance with rules, are the ones who bring about a negative approach, and then government, my lord, coolly gives it. And the whole thing is because, my lord, there is a change of government at that particular time. So both have worked in tandem to see to it, my lord, the earlier notification goes and the new procedure is introduced, which is beneficial to one sect of group of people. Now, other judgment, my lord, is 2006 SC, AAR 2006 SC.
What is the journal?
AIR, All India Report. All India Report.
AIR Supreme Court page?
1846. 2006 SC, 1846.
And what is the ratio?
Para 59, I read it, lordships. It is trite law that when one of the contracting parties is state within the meaning of 12, it does not cease to enjoy the character of state, and therefore it is subject, when the state's act of omission or commission are tainted with extreme arbitrariness and with malafides, it is certainly subject to interference by the constitutional courts. My case, followed, is that it's a clear case of political interference and political reasons. And, my lord, this is also mentioned, my lord, in 2011, 8 SCC 730.
730.
737.
All right, same ratio.
Ratio, sir, my lord, similar.
Yes.
So, so therefore, my lord, 29 has no reasons. 29 is baseless. 29 is colorable excess of power. 29 is going backwards. When there is a change of procedure is acceptable if the change is good. The change is not good and bad, not
You
only
have
bad.
said it. You have said it on more than one occasion.
Yes, Lord. Now,
Yes.
the second issue, my Lord, my prayer to Lordship's, my Lord, my prayer is twofold because challenging 29 and asking your Lordship's, my Lord, to, your Lordship sees the prayer. Prayer B is, my Lord, asking 29 to be set aside and to redo the exercise of 55, then conduct examination. Now, other ground, my Lord, is 96, GOMS number 96, which my friend have brought Lordship's kind notice. That I will have to bring it Lordship's kind notice, my Lord, just to hold for a minute, my Lord. 96 is at page 358, where slots are fixed. If the slots or rosters are fixed, that means that many open vacancies are knocked away or robbed away.
Geo 96 is also under challenge in your case?
Yes, Lord.
Page number?
96 Lordship will see at page 358.
358.
Yes, Lord. 358. We are not against 4%. You can give 4%. You have to give 4% because Act says so. The answer of the Public Service Commission, we are doing it under the Act. Act says give 4%, but Act doesn't say how you should give it. Act doesn't say whether it should be vertical or horizontal. Act
Just-
only says to give 4%. Now, my Lord, they have fixed it. Kindly see, my Lord, fixing of how they have fixed it. 63156 by amending the Rule 22. 22 is the rule, my Lord, of state and subordinate service rules, which gives, my Lord, 100-point roster, out of which 50 are for open, remaining 50 for the rest. Now, out of that 50, which were earlier erstwhile for 50, has been knocked away for 6, 31, 56, and 82. Earlier, there was only 3%. Now, it was made 4%. Because of that, my Lord, 82 is included. So, every cycle of 100, 4 are earmarked. That means that many open were dropped away. My Lord, the procedure, as your Lordships have heard now, my Lord, has to be only horizontal, interlocking. There cannot be fixing, and then actually they have done it for women. For women, there is no specific mention about saying that these are the slots. Because, my Lord, Rajesh Kumar Dharia, as my friend has read Lordships, I don't want your trouble, Lordships, and the judgment of the neighboring state, AP, my Lord, categorically said these physically handicapped women and other things which are special reservations are not within the communal reservations. Therefore, they have to be treated as horizontal, not vertical, not cubical like this. It has to be horizontal and they have to be interspersed. But whereas, in the present case, incidentally, Telangana's government understood the same with regard to women reservation. And if your Lordship sees the table that is given, my Lord, at in the notification, there are no specific, if Lordship take the notification now for a minute, Lord, there is no mention about vacancies being earmarked to women. Same thing, if your Lordship takes the table, my Lord, at page 99, there is the vacancies, my Lord, how the vacancies are to be, that 563 are mentioned at page 99. There is no mention, earlier, my Lord, there used to be OC women, BCA women, like that they used to.
We are on the validity of the geos. Kindly
Correct.
come to this geo 96 and tell us what is the
Geo, the very fixing of,
in that.
I am obliged. The very fixing of slots would mean the chairs or the
Only
slots.
which portion? Kindly tell us which portion
380.
is coming in
380.
your way, offending.
Yes, sir. 380. What is offending, my Lord, is the 358, page 358. 358.
Yes.
And kindly go to page 359, this portion, fixing of the slots. Rule, my Lord, I'm sorry, kindly come back to 358, my Lord, bottom. Clause B, the following clause shall be substituted. These are the statutory rules issued under State and Subordinate Service Rules, Rule 22. What is added, my Lord, is the following. B is added. Out of 50 appointments to be made on the basis of open competition, 4 appointments shall be reserved under direct recruitment for the persons with benchmark disabilities. To that extent, there cannot be a problem. Because the next portion, B, in clause E of so and so, the following shall be substituted, namely 6th, 31st, and 56th turns in each cycle of 100.
So you are not
Shall be
agreed by B. You are not agreed by B.
No, I am agreed by fixing the slots. 3, 31, 56. That is
Clause B.
clause B, my lord, B for Bombay, your lords.
Small b.
Small b, that's what I'm agreed of. That fixing 63156. That cannot be done is what the Rajesh Kumar Daria says. If your lordship sees by prayer, my lord, I'm challenging 96.
You are not agreed, then you are not agreed by small a.
No, they can, the 4% has to be given. Because Act says so. That's the Parliamentary Act, it has to be given.
Not agreed, no?
I cannot be agreed. I am not only fixing of the roster points. If your lordship says by prayer, I am agreed by fixing the roster points. How it has to be done has been explained, my lord, in Rajesh Kumar Daria, my senior friend has explained, lord. Just read to you, lord, right from para 6. If you just fill it up, and then have a look. If the finally you have all the 4% of reserved vacancies meant for public physically handicapped, that's a good list. If there are not many people, you can from the bottom you have to change and accordingly accommodate, but not fix. Chairs are not fixed. Spots are not fixed.
All right, for this purpose, you can borrow the argument of Honorable Senior where he relied on AP High Court judgment, Daria and DOPT and DOPT instruction and AP government instruction.
My lord, incidentally, my lord, that AP judgment, my lord, which was cited by my friend, my lord, incidentally, my lord, I have argued that matter. They were, my lord, Rajesh Daria was relied upon by me. And my lord, based upon that, AP, my lord, issued GMS number 77 by following that judgment, by treating women and physically handicapped all special reservations as horizontal only. But whereas Telangana says, I will apply this only for women.
All right, the argument will be same, no? Then in that case.
Yes, Lord. Now, in that regard, my lord, in so far as 96 is concerned, my lord, I have separately given 3-4 propositions, my lord, challenge to the physically handicapped quota being treated as a vertical reservation. I have given in the same proposition, my lord. I don't want to read it, Lord. Now, subject to what Lord Supreme, my lord, the examination is over. But there is a saying, my lord, in Telangana, der hua magar durust hua. They have to, whether it is delayed also, it has to be done properly. And just because of they cannot now say that examination is over because you are used to it. Because in 2011 also, incidentally, my lord, matter went up to Supreme Court. I had the privilege of appearing, my lord, in that case also, where, my lord, matter was. I succeeded before the tribunal, High Court, and the matter was carried to Supreme Court.
Let us confine to this case.
I'm only trying to say, my lord,
let's not travel into the history. Yes.
I'm only trying to say, my lord, they have already done it earlier. They have done it. If they have not done it properly and legally and constitutionally, my lord, they have to redo it by doing it properly, my lord. Once if the 29 goes,
that we made it clear that it will remain subject to final outcome.
Final outcome.
That depends on the outcome, yes. Anything else, Mr. Sudhir?
My lord, I am deeply obliged, my lord. I'm deeply obliged, my lord. But I lost the opportunity, my lord, physically to appear before Lord. My lord, that's my bad.
Anything else, Mr. Sudhir? Your question is over.
Yes,
anybody else wants to substitute petitioner? Kindly switch on the microphone. WP 28488.
Yes, ma'am. Of 2024.
Yes.
But I just not want to repeat anything.
Your name, please.
My name is Sainath. I'm appearing. My name is Sainath. I'm appearing for the petitioner.
Yes.
Without repeating the facts, I'll just take your lordship's to page 229 of the material papers. In the earlier round of litigation, when GO 55 was challenged, the government, the stand of the government is they relied upon the judgment of Pitta Naveen Kumar. Well, I'll just pass on that judgment here. Para 57. But they supported that 1:50 ratio is to be followed. But they cannot go beyond it. Para 57, I'll just read it for a moment.
You are relying on a judgment?
Yes. Which was which was relied by the APPS in their counter. Para 57. May I just read?
Yes.
Para 57. In total, 558 vacancies were notified. Thus, only 27,900 candidates would have been called for the main written examination on the basis of norms fixed by the state itself. However, the actual number of candidates who passed the examination were said to have been 50,726. Although actually it is stated that 32,056 candidates appeared. Thus, indisputably, a large number of candidates who have been allowed to appear in examination were evidently permitted to do so in violation of norm 1:50, as was specified by the state. The aforementioned rule could not have been relaxed. It did not have any rational basis. 66% cutoff mark was not fixed by the commission. It was arrived at by the commission in view of the marks secured by the respective candidates on applying the ratio of 1:50. Once a person falls beyond the said ratio, was not qualified. It was not to be considered any further. The state and the commission had themselves fixed 3 different states of selection process which were required to be adhered to. Therefore, now in instant case, they are going beyond 1:50 ratio. And 31,000 candidates were called for as pointed out by learners in the friends. But other 2 judgments, I am just relying on. Chattar Singh and others versus state of Rajasthan. But this judgment was relied upon in Balaji Badawat's case. But para 20 is relevant for it. Yes, ma'am. SEC. 11 SEC 742. 11 SEC 742. But may I just read para 20?
Yes.
Para 20. As regards the preparation of separate lists of general OBCs, SC, STs and physically handicapped, in view of the fact that the latest amendment has made it explicit what was implicit in Rule 13, we are of the view that separate lists are required to be published by the Service Commission in respect of the candidates in respective categories, so as to make up the number of candidates 15 times the notified or anticipated post, so as to enable them to appear in the main examination. It is true that the amendment is prospective in operation. However, it does not detract from efficiency of Rule 13 originally made. In view of the above, Public Service Commission is directed to call all those candidates that constitute 1:15 times the post or vacancies notified or anticipated in terms of the above declaration of law, so as to enable them to appear in the main examination. But this was related in Balaji Badawat's case.
So that is based on the Rule 13 there.
Yes, yes.
Rajasthan rule.
Yes. This was related in Balaji Badawat's case.
His finding is based on their rule.
Yes, yes, Manad. Rule 13 therein. But another judgment, Indra Prakash versus state
So
of.
what do you want to point out?
But this was related in
Para 20.
Balaji Badawat's case.
Balaji Badawat might have considered 15 judgments, but what is the relevance of this judgment which you are citing?
Right, they have to call only candidates 1:50 ratio only. In that case, it was 1:15, 1:5.
No, in para 20 of this judgment which you have
Yes.
just read out, how does it help your case?
But the court directed the Public Service Commission to call for candidates only 1:15 times, 15 times the number of vacancies. To that extent only.
Because their rule says so.
But
Here
in
the
the
rule is
instant,
different.
in instant case, only 1:50, it comes to only 28,270. But they have called for 31,000 and odd, as pointed out. That is what I am trying to explain. But another judgment, Indra Prakash Gupta versus State of Jammu and Kashmir. But para 28 is relevant, right?
Respective categories, this what is in respect of number of candidates in each category.
Because Rule 13 itself says so by amending it. Yes. What this 2004 says, paragraph?
But para 28.
Yes.
Para 28. But I'll just read it at that moment and RA 20 analysis. The Jammu and Kashmir medical education so-and-so services recruitment rules so-and-so admittedly were issued under section 124 of so-and-so code of the constitution, which is in pari material with article 309 of the constitution. The said rules are statutory in nature. The Public Service Commission is a body created under the constitution. Each state constitutes its own public service commission to meet the constitutional requirement for the purpose of discharging its duties under the constitution. Appointment to a service in the state must be in consonance with the constitutional provisions and in conformity with the autonomy and freedom of executive action. Section 133 of the constitution imposes duty upon the state to conduct examinations for appointment to the services of the state. Public Service Commission is also required to be consulted on the matters enumerated under section 133. While going through the selection process, the commission, however, must scrupulously follow the statutory rules operating in the field. It may be that for certain purposes, for example, for purpose of shortlisting, it can lay down its own procedure. The commission, however, must lay down the procedure strictly in consonance with the statutory rules. It cannot take any action which is perceived would be violative of statutory rules or make the same inoperative for all intent and purport. Even for the purpose of shortlisting, the commission cannot fix any kind of cutoff marks.
This is basically on the
Yes.
role of the
Role of
PS.
Public Service Commission. That's it.
Yes,
And the other submission is reservations have to be followed at all stages, at preliminary and also at the mains examination. But as pointed out by the Learned Senior Counsel, no proper segregation is done in the instant case. But my last submission is if the meritorious candidates are restricted at this stage, the preliminary stage, it will have cascading effect in the future. But their representation will be reduced in the future point of time with the respectful submission. But therefore, the injustice caused to the meritorious reserved candidates must be considered by this honorable court as my respectful submission.
That's all.
I rest my case.
Is anybody else wants to add for petitions? Your petitioner in person,
Yes, sir. This is 23907. I am pleading, sir.
how much time you will take?
5 minutes.
We have 5 minutes only.
That's all, sir.
Consume this time and please don't repeat.
Sir, commission relieves certain data after
The
mains
WP number?
examination.
No, no,
Yes,
you
sir.
are-
Implead petition.
But who is the petitioner in that case?
He is absent, sir. He
Your
couldn't
Lordship,
participate, sir.
Your Lordship, I am the petitioner, Your Lordship, in the petition number 23907, my Lord.
And you want
I am
to
Char-
be
I am-
treated as a petitioner?
Yes, sir. Implead. Yes, sir.
No, let him argue.
Yes.
Let him argue. Because in principle, whatever will be decided, it will almost be a judgment in rem for all the candidates, whether or not they are before us.
My Lord, along with the G029, my Lord, there is multi-zone violation, my Lord, committed by the TGPSC in a selection process.
Just a minute, Mr. Ashok Kumar, are you ready today for hearing? Are you ready for hearing today? Arguments? Mr. Ashok Kumar, can you hear us?
Yes, sir, yes, sir. Yes, my Lord, I have hearing, my Lord.
You wish to argue today your matter, how much time you will take?
Just 10 minutes matter of time, my Lord.
You start tomorrow then, so that in
Yes,
one
my
go
lord.
we can hear you. In
Yes,
one
my
go
lord.
we can hear you. Tomorrow, immediately after motion hearing cases, we'll take up your matter and please don't repeat. You must have heard the argument of other counsel.
Yes, my Lord, yes, my Lord,
We
much
will hear
okay, my
you,
Lord.
but please don't repeat. You may
Yes,
avoid
my
it.
Lord.
Yes.
Yes, my Lord, much okay.
Okay, in this batch matter hearing again commenced today, Shri Madan Mohan Rao Senior Counsel argued in WP 26038 of 24. Shri Sudhir completed his argument in WP 32842 of 24. 32482 of 24, and Shri Ravichandran, on behalf of Shri Ravichandran, a written note is supplied by contending that no oral arguments are required and he borrows the argument of other counsel. Lastly, Shri Sainath in WP 28488 of 24 has concluded his arguments. Because of paucity of time, as agreed, list tomorrow. This is a part that matter immediately after motion cases.
Much over, my lord.
एक ही bunch में रहने देना चाहिए. Please क्या? Please keep all brief notes and then judgments and then.
WP today is 5760.
My lord, the next 77 batch, my lord, it's Water Act, my lord, it's, your lord, so
Which batch?
it's not,
Yes, what is your request?
my lord, that whether it may be taken tomorrow or some other.
Tomorrow this batch is continuing and now Mr. Rajshekar and government, Mr. Rahul Reddy, they will consume some time.
Monday or Tuesday, my lord, any day.
Any urgency in this matter?
Urgency, my lord, it's file hearing matter for quite some time, my lord, it's coming
77.
to 85, my lord, it's 87, my lord, it's.
77 to 87 because of paucity of time as read list in the next week. Take your chance.
My last may I request, my lord? Next matter, my lord, item number 75, 76, my lord, it seems goes together. Only regarding unilateral cancellation, my lord, lordship may day after tomorrow, my lord.
Day after tomorrow is Friday.
Friday. Otherwise Monday, lordship.
What is the urgency?
My lord, it's 2008 matters, my lord, and matter for my lord referred to division bench. It may remit to the single bench or by lordships can pass orders. Lordship, it will take
Item number?
75 and 76, my lord.
Is it not 76 is 2008 matter. 75,
Yes, madam.
76 paucity of time list in the next week.
My lord.
Yes. Other matters, whenever time will be there, the registry, they will fix. We have already directed them. Yes.